a result, after 26 years, apart from the Interim Protection of Informal Land Rights Act, PILRA, which was passed in 1996 and requires annual renewal, there's still no law in place protecting insecure and vulnerable rights to land in the former homelands. Over the past few years, Janet and I and other colleagues at LARC have been working with various communities in KwaZulu-Natal. And the stories that we present today are not a collection of data, rather a recording of actual lived experiences following our field work, which we have supported with historical research, legislative background, and deeds office searches. These stories are just some of the problems. They represent just some of the problems encountered by people living in the former homelands, such as the impact of historical statutory vesting, the actions of traditional leaders dealing with land, and the failure of land administration. We're just going to demonstrate the catastrophic impacts on the lives and tenure security of South Africans in the stories that we're going to share this afternoon. And in each story, the individuals and communities have undertaken every effort to obtain some form of security, including obtaining traditional council consents, PTOs, leases, approaching COCTA, the Department of Rural Development and Land Reform, MECs and others, yet they nonetheless find themselves dispossessed and evicted or unable to achieve tenure security due to a failure in land administration. And among the case studies that we're going to present to you today, we'll start with the story of a community of Umnini, which is a story of eviction and of dispossession that has its origins in a chronicle of historical events relating to the Amathuli tribe in KwaZulu-Natal, the Luthulis. The historical events of the Luthulis resulted in the formation of the Umnini Trust in the 1860s and is the first land-owning native land trust in South Africa, and one which to this day still remains unique. And the story continues with the concerned community currently living on the tribal land I've mentioned, attempting to stop the allocation of their land by the traditional leadership, contrary to customs and common shared rules. We will share the struggles of a society, also in the same community, a society created by and for the elderly and disabled, who end up being dispossessed and evicted from their building, which was a thriving community center. I'm now going to pass over to Janet to explain this chronicle of events on a timeline, and I'll come back in a few minutes to narrate the other case studies. Over to my colleague, Janet. Thank you.
And thank you, Sise, and good afternoon, everybody. There's a lot of history here, but very briefly, before the time of Shaka, the Amathuli were a powerful chiefdom residing inland in present-day KZN. Around about the 1750s, they migrated south towards what is now known as Durban and resided on the bluff there for over 200 years, undisturbed until white settlers arrived in the 1820s. In 1845, Natal was annexed by the British and a colonial government was established, quickly setting about dealing with land, imposing policies ignoring indigenous rights, and formalizing settler land claims. As a result, parcels of land in and around Durban were put up for grant. Notwithstanding official acknowledgement of the Amathuli's longevity in the area, This included their land on the bluff. The chief of the Amatuli, Chief Umnini, aware of the value that colonial governors placed on documentary title, put in a claim for the Amatuli land. The claim was ignored, and 4,500 acres of Amatuli land was granted to a white settler. This allocation had three significant conditions: that the Amatuli would retain their rights to water, grazing, and access to ancestral graves. But 2 years later, the settler reneged on this promise, sublet the land, and the tenant thereafter forbade the Umnini and his people to trespass. This left the Amatuli in a precarious position with limited land and without access to water, grazing, or their ancestral graves. The second disposition related to the remaining land on the bluff. This involved an immigration agent who pestered the colonial government for land to the value of his certificates. In 1851, the colonial government advertised the land for sale, the remaining acres of the Amatuli land for sale. The Chief Umnini immediately protested, but was given two options: either to remain on the land or exchange it for another parcel. Given the reduced size of the land and the lack of grazing and water, he was left with little choice. And the tribe then moved some 30 kilometers south to land on the Ngababa River, to what is now known as the Umnini Trust land. Following interventions by the Bishop of Cape Town, who made several trips to the colonial office in London to complain about this, the Amatuli's right to the Umnini lands was eventually established by a deed of indenture in 1858, which also provided for the establishment of a trust, the Umnini Trust, of which Chief Umnini was one of the trustees. The land was surveyed in 1857. The survey diagram remains intact to this day, and the boundaries as reflected have not changed substantially from the date in which they were originally surveyed. It's indisputable that, save for limited servitudes acquired by the state, the title of the Umnini Trust lands was not interfered with for over 130 years until the Umnini Trust location was included in the schedule to Proclamation 232 of 86, the transfer of land and certain rights to the government of KwaZulu. The effect of this proclamation was the statutory vesting of the privately held Umnini Trust land into the name of the government of KwaZulu. The title deed was endorsed to this effect in 1990, as you can see from this slide. Just some background. Proclamation 232 is one of a set of proclamations issued on the 24th of December 1986, which vested thousands of properties previously in the SADT, South African Development Trust, and others in the name of the governments of the former homelands. The land that vested in all the other homelands was transferred to various governments and institutions in terms of the transitional arrangements in the interim constitution, not in KwaZulu-Natal. In 1994, the Ingonyama Trust Act was passed, and in Natal, all the land which had previously vested in the government of KwaZulu would vest in the Ingonyama as trustee of this trust. Just to explain the statutory vesting. Vesting by statute involves the passing of a law or proclamation with a broad brush effect that certain portions of land will thereafter be invested in another entity. An application will be made by the state, and the Registrar of Deeds then endorses the title deed to the effect that the land concerned has vested in a new entity. Proclamation 232, therefore, is the key piece of legislation which subsequently leads to the statutory vesting of the Umnini Trust land into the name of the Ingonyama Trust. As mentioned, the Ingonyama Trust Act provides that land which had previously vested in the government of KwaZulu would vest in, be transferred to, and be held by the Ingonyama as trustee of this trust. Once again, the title to the Umnini Trust lands was endorsed to reflect this statutory vesting. I'll now pass back to Steph, who undertook the field work with this community.
Thank you, Janet. To continue with the story of Umnini, the Umnini Trust land is used for residential and agricultural purposes by the community. However, common shared rules which traditionally determined access to land in the community have over the past two decades transformed into decisions being taken by the Inkosi and his Induna. The land is being sold or let out contrary to the customs and will of the community and without any consultation or the community's consent. As a result of these actions, the community formed a committee or a consent group to address the problem of their land being sold by the traditional authority. They made several attempts to report their concerns to COCTA, which resulted in the appointment of a service provider to investigate this problem of the Inkosi and the Izinduna selling the community's land to outsiders. The MEC responsible for COCTA visited the area in 2012 and announced a moratorium on all land sales until the investigation by the service provider was complete. Despite the moratorium announced by the MEC, the Inkosi continues even to this day to allocate land without the community's consent. We understand that the service provider submitted its final report to the MEC in 2015, but the report has never been made public, nor has it shared with the community despite repeated requests, including 2 prior applications. And then in 2016, the committee made an agent application, or the consent group brought an agent application seeking an order interdicting and restraining the Inkosi and the Izinduna from misappropriating, expropriating, and appropriating land from people of Umnini who were lawfully allocated such land, as indicated in the previous slide in terms of that deed of indenture Janet showed us. This case did not proceed. It was removed from the court roll on the basis that the applicants lacked standing. Within the same community of Umnini, to continue showing the abuses of power by the traditional authority, our research shows that the actions of the traditional leadership has greatly impacted on the community. One such example involves a group of senior citizens whom we anonymize, as will be in the other case studies, for obvious reasons in this province that we anonymize them. This elderly citizens group formed a society to support senior citizens and disabled members of the community in Umnini. Previously, they would meet under a tree, but in 2009, they noticed an abandoned building and in accordance with customary practice, approached the Inkosi for permission to be allocated the building so that it could be used as a daycare center. The Inkosi agreed and the premises were given to the group free of charge in 2009. The structure was in such a poor condition that the members cleaned and revamped the building with the assistance of a local construction company. The premises thereafter became a central meeting place and was used for worship, sports, and recreation. But in and around 2013, after hearing from other residents in Umnini that property could be secured via the Ingonyama Trust, they applied for a lease for the premises. But problems arose when the members returned after the Christmas break in January 2016 and found that the premises had been occupied. It transpired that the Inkosi had sold the premises to a church without notice to the society. Representatives of the group tried to reason with the Inkosi but he claimed that they had abandoned the building and allowed it to be vandalized. Following this development, the members of this society followed up the status of the lease of that building that you can see on the screen with the Ingonyama Trust board, making several long and costly trips from Umnini, which is in the south of Durban, traveling from there to Pietermaritzburg. In August 2016, the lease was signed by both parties, and this group of elderly citizens paid a deposit to the sum of 625 rand. When they went to collect their lease from the Ingonyama Trust Board's offices, they were told that the lease had been granted in error and that the site was on land granted to Eskom for a substation in 1959. And on the spot, the ITB unilaterally drew a line on the lease agreement and marked it cancelled, but they did not refund the deposit. Thereafter, the society received a letter from Eskom to the effect that electricity demand in the area had increased and that the old substation site would be the most preferred for the new substation, and the letter written to them ending with the words that this was a priority project for Eskom and they needed to commence with construction as soon as possible. Over the years, the society has written several letters, registered letters to Eskom for clarification and have yet to receive a reply. However, Eskom have not proceeded with any construction on the site. In the interim, the premises has now changed hands for a third time, and the new occupier is undertaking his own construction work. As a result, the society have not been able to use the premises as a center for the elderly and disabled in Umnini since 2016. What was once a vibrant center has been lost due to their precarious position, and they've been evicted by the actions of the traditional leader and the failure by both Eskom and the Ingonyama Trust to assist. We continue to demonstrate these abuses with another case study, which is our second case study of a farmer whose name will remain anonymous in Newcastle. This story of this farmer sees him arriving in 1979 following a series of moves for farming purposes caused by eviction, and was first removed in the Free State, in the Northwest, in Mafikeng, and ending up in Newcastle. Upon arrival in Newcastle, he was granted the use of the land he was occupying by a local farmer. Thereafter, he filed applications to buy the land to the Department of Agriculture and made several follow-up visits to Ulundi over the years. And in the meantime, he applied for a loan at the Land Bank and was given a letter of no objection by the local traditional council. As part of the farming business, he was granted a PTO, as you will see on the screen, by the then Department of Traditional Environmental Affairs at Ulundi under the KwaZulu Land Affairs PTO regulations of 1994. However, this farmer of Newcastle in 2006 received another warrant of ejectment for eviction issued by the same person who had originally allocated him land when he arrived in 1979. He again turned to the Traditional Council and obtained a letter from them confirming that he, his wife, and 10 children had been residents of the farm for 28 years, and he could not simply be evicted like that. He then set up an agricultural cooperative and invited other community members to join. And he made several trips to various government departments for funding, teaming up with the Department of Agriculture to promote farming activities in the area. However, in 2013, a relative of the landowner that had allocated him land when he first arrived visited him and claimed to be in possession of a title deed. The land that this farmer I'm talking about had been given for farming and the cooperative was then fenced and a lock installed, and they were prevented from using this land he had been given in 1979. And in the meantime, he heard that the Ingonyama Trust owned land in the area, and he approached them and was advised to apply for a lease agreement and received a letter of no objection issued by the Traditional Council, and the Ingonyama Trust sent a site officer to mark the coordinates of the land he was claiming that he had been given. However, there was no further communication after this visit by this site officer from the Ingonyama Trust, and he never heard from them again. Thereafter, a land surveyor was appointed, and he was shown the corners by this farmer. They were pointed out by the farmer, the land that he claimed was his, but the report of the land surveyor in conclusion found that the land he had farmed on since 1980 did indeed fall on land that was owned by another person, and this person had freehold title. This means that this farmer, after years of moving heaven and earth to secure his tenure with the department, the magistrate Unolondi, Traditional Council confirmations, loans granted by the Land Bank and the Department of Agriculture, and even obtaining that PTO, all these were of no use. The land that he was farming and residing on was privately owned. Towards the end of 2019, this farmer passed away after suffering a stroke. His extended family still reside on the land, as you can see on the screen, but they are under constant threat of eviction. I will pass on to Janet to illustrate the next case study, and I will return to.
Thank you, Stay. So our third case study is about one of the communities which were displaced by the construction of the Inanda Dam in KZN in the 1980s. The community was compensated with land that was acquired by the South African Development Trust for this purpose, which included properties, primarily rural land, and also some township land. Part of the township land was eventually developed. However, over the years, there were not enough houses for the families that had been displaced. It was at this point that a residents' association was formed to investigate the possibility of expanding onto the other parts of the remaining land that had been allocated to them. This was when it was found that certain transactions relating to parts of this land had taken place without consultation with or consent of the community. It was discovered that a large portion was transferred to the municipality, apparently to defray a rates claim. Just some background relating to the township land. The township land was declared a formalized township in 91 in terms of ultra, and a township register was opened. However, there were a number of challenges, a dispute with the developer, liens over the land, and eventually external consultants were appointed to resolve the legal and the land issues and to prepare the township for development. All actions appear to have been completed in 2004. However, the final step, the appointment of conveyancers to deal with the transfer, for some reason, yeah?
Sorry to interrupt you. Can I ask you to work towards wrapping up in the next sort of 2 minutes or so?
I'm almost finished.
All right.
Okay. Was not concluded, and the land remains registered in the name of the Minister of Regional and Land Affairs. The other properties that were allocated to the community in compensation for the inundation of their land by the Inanda Dam were transferred in terms of ultra, whereby the minister may transfer tribal land, the control of which vests in a tribe, to a tribe in ownership. These titles were registered in the deeds office in the name of the tribe under the chief who is named. It appears that the chief was able to deal with this land, perhaps by the way in which owner was recorded in the title deeds. The vesting in the name of the tribe under the chief is in reference to a state president's minute issued in terms of the Black Administration Act. I just point out that powers of attorney permitting the transfer of portions of this land to private individuals by sale or donation were issued referencing this minute and the Black Administration Act at least until 2014. I'll just be very quick, Anna, just to say that while the Black Administration Act was repealed, it was only repealed incrementally. It's an example of legislation that has an afterlife. The Deeds Registry Act provides that provides that despite the repeal of regulations made under the Black Administration Act, certain transactions concerning the right originally applied in terms of this act can continue to be registered. I'll just say that the Residents Association has really gone to huge efforts in this community. They've been to COGTA and the department to no avail, and they found that portions of the land allocated to them in compensation for the loss of their tribal land has been sold or transferred without consultation. Land has been sold to the municipality, has not been developed, and is now occupied by informal settlements. In addition, the community have now lived in the township for nearly 30 years, and due to a failure in land administration, are yet to receive a title deed.
Chair, we say that notwithstanding the protections envisaged in the Constitution, our examples evidence situations of people affected by legislation and resulting statutory vesting, the actions of traditional leaders, and by a failed system of land administration in the former homelands. In spite of their enormous efforts, individuals and communities don't have security of tenure and are vulnerable to dispossession and eviction. The insecure land tenure affecting so many South Africans must be addressed by Parliament. And we believe that this is a daunting task, but we owe it to the future generations to solve this conundrum. We thank you for listening.
Yes, thank you very much.
The translation process in the in-person venues. So I'm going to ask the venues to mute themselves and to do a very quick translation of that input.
Dumela magaisho. Kholofa go bua ka property e leng go KwaZulu-Natal. E le gore na le mathata. Sa ntlha property go te e siale mo mabogong a mararo. Agere e tsene mo o ya tswa mo go o ya tsena mo o ya tswa mo ya tsena go. And then mathata le nteng ke gore go kupile sa ntlha morafe gore ba fiwe moago o gore ba kgone go dirisa. Go tsweng fo ga se ba tswa mo Christmaseng ba fitela rona le batho ba se ba ipele mo morafeng o mo moagong o. So ke mathata a tlhageletseng. E be nna gore Ingonyama Trust agere re bitsa ITB board ke a ba simolola ba re lona ba gaetsho ga la tshwana nna mo plekeng pleke ke pleke a Eskom agere wa bona. So e be nna mathata gore ga ba re pleke ke pleke a Eskom ke a go tla fiwa bangwe gore pleke eo ba e dirise. Ha ba fetsa ba tlhabolola pleke ya nna sentle. Ga fetsa go tlhabolola pleke eo e be nna gore the very same Ingonyama Trust board ha ba fitlha ba no di filwe ke mang plekeng ga nna tetla re lefuwe pleke a kry nagana batho ba patetse tšhelete ba tlhabolotse pleke ga go fetsa ebile ba cancela lease agreement e saenilweng gore ba ka dirisa moago ga ba fetsa cancela lease agreement batho ba fiwe madi a bona wa bona ke mathata a leng teng so ga o ka ela tlhoko mathata a ntse a diragala ko KwaZulu-Natal ka ntlha ya mafatshe ke dilo tse di tswa kwa lowe wa bona and-e ke dilo tse ntse dirwa ke Ingonyama Trust board seng kgone go na le di-court case mabapi le Ingonyama Trust board so ba tlhalosa gape ka ntlha ya sone sena ya Inanda dam go na le tamo le le bitswang Inanda gona ko KwaZulu-Natal so letamo leo se ba se tlhalosang ke gore go bile go nna le gore go thusiwe batho foo gore go feleletse go dirwa letamo leo mme ga go thusiwa batho foo e be nna gore go atele re lebeletse pleke re tlosa mo lona gore re batla go dira gape township fo teng o tlosa batho ba selegae o batla go dira location wa utlwisa ke mathata a leng teng a dirwang ke ketapele re na leng yona ke a go tla simolola go ba le go isana ko kgotlatshekelong go tsena babueledi yaanong gore go kgone gore go mekamekwane ka ntlha ya yona lefatshe le ntse go bua ka lona mme yaanong ke a go simolola yaanong go tseiwa gore yaanong ba tsa lona lefatshe leo ba go le registera ko deeds office a kry bona gore ba kgone go kry-a title deed e ntse re bua gore but communal land ba gaetso wa tshwanetse ko bofelong go bane le title deed ya batho ba e leng gore ba dira kgwebo mo teng yaanong go na le matsapa gore title deed eo go dirisitswe molao wa 1937 ga o ka ela tlhoko ke melao ya kgale e dirisitsweng go registera that particular lefatshe leo mme go tsweng foo e be nna gore go na le portion e nngwe e rekisitswetseng masepala kore kgone bona lefatshe le kgaogo ya di-piece la kgaoganya lefatshe di-piece ke mathata a mangwe a leng teng mme go tsweng foo ga se ne le rekisiwa masepala fale e be nna gore go nna le metseletsele ya gore dikgotlang gare ga batho magosi ga mmogo le selo sela le re bitsa international council akere e tsamaiso sepuso se ya selegae so ke dingwe tse e leng gore ba tlhalosa gore melao e dirwang ke puso e gatelelang batho re tshwanetse re e loseng bagaetso especially ga re tla mo lefatsheng ka gore batho ba latlhegelwa ke mafatshe a bona ka ntlha ya melao ke lebogile bagaetso
We can actually put that up on our leadership. Adina has created a checklist for Tom, and she can.
All right, thank you very much, colleagues, for the pause to allow for translation. Apologies again to the online participants. This is a mechanism just to facilitate wider engagement. I'm going to move then to our second speaker, who is Dr. Aninka Claessens. Dr. Claessens is the former director of the Land and Accountability Research Center, and she will be speaking about the Ingonyama Trust judgment and the implications that it has for customary ownership and the Communal Land Tenure Bill policy approach. Aninka, over to you.
Thank you, Nolundi. So basically, Janet and Ster have provided examples of problems of tenure insecurity facing ordinary people. And they have talked about certain fault lines that run through and inform these problems. And I'm going to talk about how those fault lines are really exacerbated by the communal land tenure approach. And in the main section, I'm going to discuss the Ingonyama Trust judgment and illustrate that that judgment actually shows that the policy approach set out in the Communal Land Tenure Bill is unconstitutional, is in contravention of customary law, and it also is in contravention of statutory law, being the Interim Protection of Informal Land Rights Act. So just to start off with Janet and Ster's input, where they highlighted three key problems that inform current tenure insecurity. One is historical vesting, that process in 1986 where the apartheid government vested all the land in the former homelands in the homeland governments. The other is the problems caused by the power vested and exercised by some traditional leaders, and the last one being the serious failure of land administration. So Janet and Ster illustrate the dire results of that political vesting, where those political boundaries were overlaid on pre-existing land rights. Now, the Communal Land Tenure Bill defaults to exactly the boundaries created by that historical political vesting of land in the former homelands. It applies only to land in the former homelands. That's thereby setting up a segregated system of land rights throughout South Africa. But more than that, it provides that within the homelands, land will be transferred in ownership to either traditional leaders or traditional councils. So land belonging to ordinary people and occupied and used by them over generations will become part of title deeds held by traditional councils or traditional leaders. The Communal Land Tenure Bill also entrenches the power of traditional leaders in relation to decision making, and it provides no effective countervailing land rights or accountability mechanisms. And we've already seen that even prior to that bill being enacted, the actions of traditional leaders and the Ingonyama Trust is included here have led to wholesale dispossession in some areas, not in all areas, but in some areas. And then there is this terrible problem of the breakdown of land administration throughout South Africa, which I'm sure we're going to hear more about in other sessions. Basically, the Communal Land Tenure Bill has incorporated some kind of internal rights for occupants and residents because they know there's going to be a constitutional challenge. But those rights would need a very robust system of land administration to be recorded and to be endorsed and to be implemented and to be enforced. And there is no such system. Plus, those rights would always be subservient to the title held by the traditional council or the traditional leader, and the powers, the explicit powers vested in traditional leaders by not only the Communal Land Rights Bill, but the Traditional Khoisan Leadership Act. Now, the underlying assumption of both the Communal Land Tenure Bill and of the Ingonyama Trust is that communal land is free for the taking, that it's in the gift of the state to transfer to whoever it wants, to transfer to traditional leaders or to transfer to the Ingonyama Trust. And what the Ingonyama Trust judgment does is it resoundingly rejects that premise that communal land is vacant of any pre-existing rights. It uses the Constitution, it uses customary law, and it uses the 1996 Act IPILRA as a basis for proving that there are pre-existing property rights on that land. And it's those property rights that the 1986 homeland vestings that Ster and Janet referred to, and that the Communal Land Tenure Bill seek to obscure and to undermine. So at this point, I'm going to share my screen because I'm going to discuss a whole lot of examples. I'm going to take extracts from the judgment. So hope I can do this. Yeah, there you are. Okay. So, but to give you some background before I do that, what happened with Ingonyama Trust is that the Ingonyama Trust decided to cancel records of all pre-existing rights, and those were mainly in the form of PTOs, and to tell people that if they wanted tenure security, they must take out residential leases. And if they didn't take out residential leases, they were threatened with eviction. And what that has done is it forced people to take out residential leases, and they ended up paying for land that they had occupied and owned for generations. And this is not a problem that is only taking place in KwaZulu-Natal. In many other parts of South Africa, we have traditional leaders demanding levies and payments for land that people have owned for many generations. So the court said that, how do I make this? Okay, slideshow.
Yes, thank you.
Okay, the court basically said that under customary law, each member of each class or community is entitled to an allotment under customary law. And once that has been allocated as residential or arable land, it is taken out of the realm of communal ownership. And it belongs to that particular family for generation after generation. That's reiterated in this second slide, where it talks about the inviolable nature of these property rights that belong to those families and pass from generation to generation. And it bases this judgment not just on customary or indigenous legal systems, but also on statutory law, that's IPILRA, and the Constitution. And it finds that contrary to what the Communal Land Tenure Bill assumes, and contrary to what the Ingonyama Trust insisted, that so-called communal land is full of ownership rights held by people in terms of customary law, in terms of constitutional rights, and in terms of IPILRA. Now, this idea, which is ignored by the Communal Land Tenure Bill and the Traditional and Khoisan Leadership Act, that customary rights constitute ownership, is not a new thing in South African law. So it's quite extraordinary that these bills are premised on the fact that this land is free for the taking. Because from the 1960s, Professor Alistair Kerr wrote textbooks about the de facto, the actual content of customary law, and showed it was ownership, both pre-statutory customary law and post-statutory customary law. We have even the apartheid government recognizing in 1991 that a whole lot of the different forms of land rights that people were forced to have under apartheid were discriminatory and must all be upgraded to ownership. That's with the Upgrading of Land Tenure Rights Act. So that is an acknowledgement that these underlying rights should have been ownership and were only not ownership because of apartheid. Then we've got Section 25(6) of the Constitution, which Esther read out, which confirms that anyone whose rights are insecure because of discriminatory law is entitled to tenure security, and there must be a law to give effect to that. But the only law we've got is IPILRA, which is a very basic bottom line protection dealing with the most basic element of of property rights, which is consent against interference. And that was so basic because the Land Rights Bill was in the wings, about to be enacted, but never was. Then we come on to court judgments. So contrary to the way in which Parliament has acted in introducing legislation that ignores these underlying property rights, the courts, especially the Constitutional Court, has recognized these property rights. So you have the Alex Call judgment about Richtersveld, which found that customary rights to land were ownership, not like ownership, not akin to ownership, but they were ownership. And then you had the Tongwani judgment, which struck down the previous Communal Land Rights Act, which is basically the same as the Communal Land Tenure Bill, and although that judgment was a procedural judgment about how Parliament had gone wrong, not about what was wrong with what it did to land rights, it did warn that the Communal Land Rights Act trespassed in an area that was not vacant, that was full of rights. In other words, was full of customary law rights. And then we have the important 2018 Maledu judgment, which upholds IPILRA and the Constitution and informal rights in the face of this incredibly common assumption that mining takes precedence over everything in South Africa, this legal assumption that it takes precedence over everything, even the Constitution. Now, the Ingonyama Trust judgment goes further than either Alex Kor or Maledu, because those talked about the community's rights, communal ownership, whereas Ingonyama Trust judgment talks about the internal customary law rights held by individuals and families, and it talks about who specifically has decision-making authority. So decision-making authority is an intrinsic component of property rights. You don't have property rights if you can't exercise those rights. And what is so bizarre about the Communal Land Rights Bill and about the Traditional Khoisan Leadership Act is that they try to take the decision-making component of land rights away from the holders and give it to traditional leaders. But that is consistent with their refusal to acknowledge that people have pre-existing property rights. So if you look at this paragraph 101 of the judgment, it talks about the rights of people in terms of customary law, and it talks about their rights to use land, to dispose of land, to erect a building, to let it, to transfer it, or to bequeath it, to give it, to leave it to your children. Now, those are all forms of control that the Ingonyama Trust took to itself through the leases policy. It took away all of those rights, all of which entail decision-making authority, and it gave all those rights to itself. Now, consent to stop deprivation is the most basic of property rights. You know, these other rights get added to it: occupation, to use it, to dispose of it. And basically, IPILRA protected that most basic and continues to protect that most basic of rights. And what this judgment really deals with is rights of occupation and use. In other words, rights to houses and fields. It doesn't really deal with common property rights, rights to shared land. And that is very, very important category of land, because that's often where the development takes place, on the grazing land or in the forests or whatever. And although that is beyond the scope of the judgment does make reference to the fact that just as people have strong and secure rights to residential and arable land, they also have strong and secure rights to commonage, and to, which is grazing, woodland, all those other things. And it reiterates, and this is from the judgment, the terms of IPILRA, which differentiate between processes of consent in respect of occupied and used land, in other words, houses and fields, and where land is held on a communal basis. And it says that where land is held on a communal basis, you need the consent of the majority of the people affected. Now, this is completely different from the idea that the chief can make those decisions on behalf of the tribe. So that what you've got here is the decisions are taken by the people who've got shared access rights. In other words, they've got IPILRA rights, not some bigger entity headed by a traditional leader. What the judgment finds is that the trust arbitrarily deprived people of their property rights. It says that its program of leases amounts to an arbitrary deprivation of the beneficiaries and residents' PTO rights, customary law rights, and informal rights or interest in the land. And it says that that deprivation of rights is not only in terms of customary law, but also the Trust Act, also PILRA, and the Constitution. Because one of the key provisions of the Constitution is that there cannot be arbitrary deprivation of property. So what it means for the Communal Land Rights Act is, for the Communal Land Rights Bill, is that if the state were to enact that bill and to then transfer ownership and control of land owned by families to traditional leaders without expropriating their rights, it too would be guilty of arbitrary deprivation of property. So I think, you know, the Ingonyama Trust judgment really is a very, very stern warning to government about the approach that it's seeking to adopt with the Communal Tenure Bill. Now, the question is, will this judgment turn the tide? Will it force government to actually recognize that people have got pre-existing customary law rights on this land that they plan to give to traditional leaders? Will it send the drafters of the Communal Land Tenure Bill back to the drawing board? And it's unlikely that it will, because the debate about those bills is not a debate about property rights. It has been completely dominated by a debate about the status and the powers of traditional leaders. And that debate about the powers of traditional leaders completely hides the property rights that are at stake. And here we see Judge Madondo saying in the judgment that it's sad to see Mr. Ngwenya, the head of the Ingonyama Trust, trying to say that this litigation is an attack on an affront on the institution of Ubukosi, rather than an exercise of people's rights to protect their property rights. And, you know, he talks about the fact that this case is not about the role and constitutional status of the king, which is what the Ingonyama Trust always tried to make it out. They tried to threaten the applicants in this case by saying they have insulted the king, whereas the judgment makes clear that all these people were trying to do was to actually enforce their property rights and protect their property rights from arbitrary deprivation. It's a deep irony that the traditional leaders and the Ingonyama Trust, who are demanding these land transfers, are supporting the idea of absolute ownership and title deed ownership, which is a Western construct, at the expense of any kind of recognition of customary forms of coexisting, long-established historical rights. So in a sense, they are using Western constructs of property law to trump the kind of tradition that they pretend that they want to uphold. So, you know, in a way, this is a very refreshing judgment. It's by a self-avowed traditionalist. Deputy Judge President Madondo calls himself a traditionalist, but he has cast customary law as a source of rights and of decision-making authority for ordinary people, and not as a blanket to obscure ongoing processes of dispossession. Now, it must be noted that leave to appeal has been granted. The Ingonyama Trust has applied for leave to appeal, and they've got leave to appeal, but only on very limited grounds. And in a way, we need this judgment to go to a higher court, because at the moment, it's only got the status of a judgment at the high court level. And, you know, it's actually beneficial that such an important judgment should be at a higher level. And that's what's going to happen through this appeal process. But in the meantime, all the processes that were put in place to defend people against the Ingonyama Trust have unfortunately been put on hold. So I'm going to leave us there. Tembeka will now lead us in a discussion about alternatives. And really, what we have at this stage is we have a political trajectory by Parliament, which is all about appeasing elite interests, And we have a clear direction given to us by the Constitutional Court about how customary law should be upheld and land rights should be respected. And somehow we've got to break the unfortunate contradiction between the two so that we can move into an era where our policy, our land tenure policy, is informed by the Constitution and securing rights rather than appeasing traditional leaders and other elites. Thank you, Nolundi.
Of pause to allow for the translation process. Thank you very much to Aninka for that input. I'm going to give again a really short period of time to the venues to please do a brief and succinct summary translation of that presentation before I introduce the next speaker.
Okay, is it on? Kaburipana, Dr. Tlasen over I, Utomika Gatelela, Dintachetaro, Wamatata Mararu Adru Wakumani, Udumura, Peroyela ya, Ste Leginet, Molongore, Gidin Tache Longore, Kematata Longore, Ibile, Ubakonoa Pika, O Katoloyela ya, Koroteko, Ingonyama Trust, Molongore, Kaburipana. Katoloyela ya Ingonyama Trust e kgona go ntšhetša nyanyeng mathata a leng gore molao ka kanywa o re be le ona wa peakanyo ya mabu mo ditšhabeng tša borena o tlang le ona mo leng gore ge re lebeletše ditsopolwa go tšwa go katlholo ya kgorotsheko ke ya gore Ingonyama Trust ka mokgwa e šomang ka gona e fihlile le mo leng gore e gatelela ditokelo tša batho ya di gata ka ditokelo tša batho tše leng gore ke kgale di le gona ene ebile di gona mo ditšhabeng le ka mo malapeng ene ebile ile ya išetša fase ditokelo tša batho tša bodudi ya dia gore e be bahiri napile e fetša e dia gore batho ba patele for ditokelo tša bona ene ntouwe goba tiragalo ye ya gore batho ditokelo tša bona tše ba be le tšona tša go dula ba fetse ba di patelela mo ba dulang gona go patelela boroko ga e diragale fela kwa KwaZulu-Natal mo le Ingonyama Trust e gona le di-provinceng tše dingwe ka gore re a tseba gore batho ba patela dikgorokgoro diyelwana tše dingwe le a tseba le di bitša eng mara na re di bitša dikgorokgoro ka kua mara ke tribal levy ge ya pele motho o mongwe le mongwe e leng gore ga a kgone go ubamela molao wa go patela o patelela boroko go ra gore o a rakwa go mabu o tukotse le gore bana le tšona ene mabu aue a o kgone go a fa bana ba gago le ba bangwe le go laola rena o ka šomiša jwang ene bothata tlhotlho e kgolo e ba kudu mo e leng gore ke mabu a re a šomišang ka kopanelo re a tseba gore kwa dinagamagaeng phulo o ka se kgone gore mo go fodisa dikgomo tša ga serame fela re fodisa re tlhakanelane ene ge re tlhakanelane go ra gore ditšhaba di be di palela le go tšea le sephetho na di palela le go tšea sephetho na re šoma jwang ka mabu a neue kudu go tla go ba ditlhabologo ka re e tšea maatla a diphetho tša ditšhaba le batšhomiši ba mabu ba e fa magoši ene e fetša e thekgwa ke molaola ba reng ke ko mongwe wa di-bantustan molaola wa TKLA ne ke ona o fetšang o ikare le ona o re magoši o a file maatla gore ba tšee diphetho legatong la ditšhaba mara le gore ba sa dule mabung a ona ande ke nto e kgolo gore molaokakanywa wa peakanyo ya mabu ko dinagamagaeng o fela o tšwela pele o re magoši a ba tšwele pele le go le tšeela diphetho ene seue se kgatlhanong le karolwana yela ya bo 25 subsection number 6 ya molaotheo mo leng gore molaokakanywa ka bona go ra gore o lwa le molaotheo ene ke ntho e leng gore re ka se kgone go ikgotlelela ka re e tšwela pele le gore ba le ba e leng gore ba šetše ba le kwa godimo a ba tšwele pele le go ba kwa godimo e dire molaokakanywa o thabiša bona go na le go tiišetša ditokelo tša batho ba e leng gore ba dutše go dinaga tša magaeng ke a leboga
Thank you very much for giving us that moment of pause. I'm now going to introduce our third and final speaker for this plenary, Advocate Thembeka Ngcukaitobi, who is a practitioner at the Johannesburg Bar. Advocate Ngcukaitobi is going to speak, as Ninka indicated, a little bit about alternatives, but also is going to speak about some of the issues from the perspective of crafting a different way of thinking. Over to you, Thembeka.
Thank you, Nolundi. I'm very pleased to be here and to have been invited to the conference. I also noted that there are people in Durban and in East London and in Johannesburg, so I presume I can dip in and out of my native language, isiXhosa. So with your permission, Madam Chair, ndizawumane ndicacisa ezinye izinto ngesiXhosa ukwenzela into yokubana kungamane kutolikwa yonke into kuthiwa isiXhosa asitolikwa.
That's perfect, Ngozi.
All right, ndiyabulela. All right, so the topic I'm going to be dealing with, according to the program, is the constitutionality of the Communal Land Rights Bill. It's a bill that goes together with a policy that was passed in 2014, or at least adopted in 2014. So, ekokuqala ke sithetha ngantoni xa sithetha ngalo mthetho? Sithetha apha ngomthetho oyilwayo, le nto kuthiwa i-draft bill. Uyilwa ngurhulumente kuba ufuna kwezi ndawo kuhlala kuzo abantu abamnyama isikakhulu. These were previously Bantustans. Ngamanye amazwi kumane kusithiwa ke communal areas. Phambi kokuba kuthiwe zi-Bantustans, zazi kade zizaziwa njenge-native areas. Kukho ke umthetho oyilwayo osepalamente ngoku sithethayo, ojongene nento kokubana umhlaba okwezi ndawo mawuphathwe njani na ngurhulumente, ziinkosi kwanye nabantu. Igama lalo mthetho ke yi-Communal Land Rights Bill. Awufiki ke lo mthetho, ufika okwesibini. Wawuqale ngomnyaka ka-2004. Inkundla yomgaqo-siseko ngomnyaka ka-2010 yathi iinzame zikarhulumente azingqamananga nomgaqo-siseko, wacinywa ke lo mthetho. Kukho mtsha ke ngoku, nguyo lo sithetha ngawo namhlanje. So what do I think about the Communal Land Rights Act or the draft bill? Let me stake my claim at the outset. I believe that the draft bill, if passed in its current form, will be unconstitutional. Some of the reasons for that belief have already been alluded to by Aninka. But let me add further reasons why, if that bill is passed in its current form, it would be unconstitutional. The first is we have to look at the theory underpinning Section 25(6) of the Constitution. Leli solotya ke linika amalungelo kurhulumente, usolotya 25(6). Uthi ke ngesingesi, a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled to the extent provided by an act of parliament, either to tenure which is legally secure or to comparable redress. Now, the section specifically refers to racial discrimination. And in this sense, it must be read together with Section 9 of the Constitution, which also outlaws racial discrimination. But in addition to outlawing racial discrimination, it imposes a duty on the state to take positive measures to dismantle patterns of existing racial discrimination. So the first theoretical underpinning of Section 25(6) is that it is an equalizing right. And the second element to Section 25(6) is that it's located in Section 25, which is a section intended to transform property relations that were created under apartheid. So the second theoretical basis for that section is that it's a transformational right. Now, both the equalizing and the transformational are central to understanding what law may be passed under that section. Because we also have Section 7 of the Constitution that imposes a duty in Section 7(2) to respect, protect, promote, and fulfill the rights in the Bill of Rights. Now, the question then is, how does the bill see the role of the different institutions that are involved in land administration and land ownership in the communal areas? The dominant element to the Act is it believes, Aninka says it believes that there is a legal vacuum in relation to the land that is held by communities. But I want to argue that what the premise of the Act is, or the bill is that it believes that the land in communal areas is actually state land. And it can be controlled by the state through traditional institutions or traditional leaders. That is a historical problem, right? When you consider where this comes from history. The state has always put the chiefs between the government and the people and entrusted them control over the land. This is clear from two pieces of legislation. The Native Administration Act of 1927, as well as the Native Trust Act of 1936. When you read both of them, the one creates a trust in order to control native land. The other creates traditional institutions that are accountable to the government in order to exercise political control over native people. The combination of these two, political control over native people, extended to political control over land. Now, Aninka is being too generous to the government when she says they regard communal areas as a legal vacuum. I argue that there is something more sinister, which is they regard those in the same way as the colonial and the apartheid state did. That the true political power is inseparable to control over the land. Now, that's problem number one. Instead of transforming existing colonial and apartheid relations to the land, the risk is that the Communal Land Rights Bill will entrench them. So it does not serve the first of the two theoretical underpinnings to Section 25(6). It's a regressive law. Instead of taking us forward, it's taking us backwards. Secondly, what's wrong with it? Second problem with it, it uses a vague notion of community, right? A vague notion of community. So Anika spoke about the 60% requirement for passing various decisions. You'll find it in various parts of the legislation. Various decisions are to be passed by 60% of the members of the community. But this notion of the 60% of the community renders invisible, right, the individual and the family. It renders them completely invisible. They disappear. So you can go into a hall, to a big meeting, and in that big meeting, someone else will make a decision about whether or not your plot of land, right, should now be registered for ownership by the community. The mere fact that you object will simply be taken into account by someone else will make a decision on your behalf, right? Why is that a problem? It's a continuation of the colonial construct to native land, because the colonial construct towards native land never regarded it as being capable of individual ownership or individual control in the same way as European land. So that clash of the European construct towards the land versus the traditional African customary, whatever terminology that the colonists constructed, lives through, right, the bill. It lives through the bill because it still does not realize that the native is as capable of exercising autonomous rights over a piece of property, right? Now, this is an old problem which the bill carries through. What's wrong with that? What's wrong with that? I mean, firstly, there is the colonial gaze, but there is also the problem of the power relations that have calcified over time in favor of men and in favor of traditional leaders. So the marginalization of women and the marginalization of the people in the name of the chiefs, which means it's again not serving the second theoretical underpinning. It still treats Black people, African people as subjects, right? So it's not serving the equalizing role. Now, these are the two problems that cut across the various sections that you find in the bill. Whether one talks about Section 28, which deals with what is called land administration and the choice on land administration. You know what will happen for those who are interested in this? When this bill comes into operation, this is my third problem with it, which is the actual administration on a day-to-day basis. When it comes into operation, you will have a scenario in which a community, and again, there is an ambiguous definition of a community that ultimately suggests that a community is a place that has a chief as its leader, right? So when you say community, doesn't mean really people, it simply means it's got that traditional community element to it. And if you read it together with the other pieces, the community is the place that is run by the chief. So once the bill comes into operation, there will be various choices, right, in which so-called community may make a choice about how to administer the land. Number one, under the traditional council. Number two, under a communal property association. And number three, under any other entity as may be approved by the minister. So that's going to be the administration structure. So think about it. Community already includes a traditional council, but the section also adds a traditional council as another vehicle for the administration of the land. And then think about a communal property association, which in 2013, the department said, communal property associations do not work, they should be scrapped. And then think about any other entity that may be approved by the minister. So we are back again to traditional authorities. So there is an ongoing entrenchment of the role of traditional authorities to the sacrifice of true community decisions. This is odd. Why? Because the ANC claimed that it wanted to implement the Freedom Charter. That's why it got into power. And the Freedom Charter says the land shall be shared among those who work it. It never intended that the land would now be controlled at a state level or at a traditional authority level. It always intended that it would be owned at communal. It was always a bottom-up approach. So we have a bill that is neither equalizing nor transformational as required by Section 25(6) of the Constitution. What are we going to do about the scenario? Option one, Aninka has spoken about, which is we have the judgment that has just been delivered by the KwaZulu-Natal High Court that is beginning to talk meaningfully about customary law. And crucially in that judgment, it's not referring to an idealized form of customary law that is pre-conquest. It is talking about living customary law. In other words, what are the experiences of the people now? And that's the customary law that the Constitution has in mind, right? It does not talk about a fossilized, calcified version of pre-1652. It's talking about today's version of customary law. So our duty now is providing a fuller theorization of what is customary law in relation to land going to look like post the CASAC Ingonyama Trust Board judgment. So it's giving effect to the notion of living customary law. What does living customary law look like? It's non-discriminatory. It is participative. It is not gendered. It is future-looking. It incorporates the youth. It dismantles patterns and structures of patriarchy. In other words, it's truly modern, right? The second thing, quite apart from a fuller theorization of customary law, is we have to be explicit in rejecting the bill. The bill needs to be scrapped, right? And rewritten. When it is scrapped and rewritten, communities don't want a bill drafted for them by the government. They want a bill in which their views are reflected. So step number two is a clear political demand for the scrapping of the bill and a new bill that is not going to be drafted from the top down, but it will be drafted from bottom up, right? Many communities know what they want. And the law's duty is to reflect what the people say, not what the politicians say. They went there on account of the fact that they were representing our interests, not their interests. Step number three is building robust institutions of customary law. building robust institutions that support community structures. Many people have criticized communal property associations. They have weaknesses, but they still remain the most viable instrument for the carrying out of community interests. A demand ought to be made about availing resources and strengthening the existence of communal property associations and appending power relations so that those decisions are made explicitly by communities. Number 4, it is not as if we are operating in the dark. We do have an alternative piece of legislation. It's called IPILRA. But IPILRA was done on an interim basis. But it sets out very basic protections. And unlike the Communal Land Rights Bill, its starting point is the individual, right? Its point of departure is the individual and not a nebulous notion of a community. So it's building. We are not going to be left in a vacuum if we scrap the Communal Land Rights Bill. So it's step number 4 is building IPILRA up. Making it permanent is an option. Making amendments to it is an option. But the key to this is it is not for us, the elites, to decide, to create the structures that truly empower people to make their voices heard. Step number 5, and this is the last, is winning our case at the Supreme Court of Appeal. Thank you, Nolund.
Thank you very much. Thank you so much, Tembeka. Colleagues, again, we're going to take a moment of pause to allow for the translation process in the in-person venues. Following that, we'll move straight into a Q&A engagement session. We are going to run a little bit behind with our program, but I don't want to close the plenary without offering an opportunity for people to engage with what has been said. So again, to the online participants, you will hear no sound for a period while we do the translations. Please go ahead.
Yeah, mo Robert Hedije Rona. Ntlha ba e bontšitšeng ka kudu ke ela ya gore magoši go no swana le nakong ela ya kgatelelo mmušo o sa no tšwela pele go ba šomiša go bang go ba didirišwa tša go gatelela batho. So ka mantšu a mang ke bona ba lego kae ba lego at the forefront, and then le gona go bona gape gore ge go itlamola tabeng ela ya melawana ela ba e dirilego ge re lebelela wa customary lo tradition. So ka mokgwa di lwang ka gona ke ka baka la gore o mongwe ba o šomišitše gore o dirang go šomiša go kgona go tšea naga, o mongwe ba o šomiša mo la tabeng ela ya sepolotiki. And then yung mga gape ba ako nung go bontšhana le yona ga botse mola ke tabeng ela ya gore se molawana o moso o swantse go o diriwe o swantse o lebelela tabela ya go hlompha go godiša gape le go fulfilla sela se leng kae se leng gona mola ga the Bill of Rights. And engwe gape and then engwe gape ya bontšhitšeng yona gape ke tabela gore taba ela ya gore naga ela batho ba magaeng ba dulang ga yona ba fela ba bolela gore ke ya mmušo, mara se se bonagalang ga botsebotse ke gore taba ya gore ga se ya mmušo. Naga ela ba file magoši maatla ka gore ke bona ba nago le taolo e ntšintši tabeng ya gore mang o e šomiša go dira eng, o mongwe o e šomiša go dira eng. And then se o bontšha ga botse gore se tšweleditše keng ke melawane mebedi o mathomo o phasitšego ka 1927, and then lo mongwe wa phasitša ka 1936. Wa 1927 ko la bo bontšha kang ka taba ya trust act, taba ya gore na mabu a tlo laola jwang. And then ola wa 1936 ko le gore mostly bole political tabeng ya gore na batho ba ba dulago magaeng kana re ba buša ka tsela mang. And then e nngwe gape a e bontšhitšeng ke tabela gore sephetho se gantši re se tšeang ka tabela ya 60% ya gore re dutše re a vouta se buetša se tšeela batho ba bang ditokelo go swana le motho ge ke le so ge ka kopaniwa ka holong ba re ba rekiša naga yaka nna le ge nka gana mara ge batho ba 60 ba kgonne go dumelelana so ra gore di dirwang ya fetišiwa so ka mantšu a mang ditokelo tša ka goba tša family yaka di dirang di a kgona go gatelelwa so ke taba e leng gore e santse e lebelelwe morago. And then e nngwe gape e a bontšhitšeng ka yona mohlomong ke tabela gore na ge dilo le ka mokgo di-option tše re na le tsona ke tše di feng. And then go na le option tše 5 tše a di bontšhitšego and then ya mathomo o bontšhitše gore ka hloloela ya Ingonyama Trust ka baka la gore e tšo bontšha gore motho batho nage ba e šomiša ba na leng le tokelo godimo ga yona so ke nngwe ya dilo tše e le gore santse re tšwele pele re bontšhe ka baka la gore ba šomišitše iphelelakere ke yona beele gare ka gore e recognize tokelo yang ya motho go naga gore na o šomiša naga jwang. And then ya bobedi a re option e re na le yona ke ya gore completely re reng molaokakanywa o leng gona ba santse ba o direng ba o tloše and then o tsamaye o ya go ngwadiwa ka leswa.
All right.
And then ya boraro ge molao o ile o ngwadiwa ka leswa e se ke ya ba re borra dipolotiki bao ba o ngwalago e beng batho kua fase go thome rena re bolele gore na rena re dula go magaeng re nyaka go bušiwa ka tsela mang.
Take a few
And then
inputs
ntlha ya
and
bone
questions.
ke la gore
My sincere
gore
apologies for
iphelera
not
ka baka la
going
gore
to get to
e
everybody.
thoma e lemoga gore
The way that I'm going to do it is I'm going to
motho o
encourage
na
those who are
leng le
participating
ditokelo
on the
so e
online
na leng
platform.
a very good
Please
starting
continue
point
to post
se re
your
ka se
comments and
bolelang ko gore
questions in the
e se
chat.
ke a hlweleng e
I
le ya
will ask
temporary na pebe
speakers to please keep an
ya go
eye
ya
on
go
the
ile.
chat. So
And then ntlha ya
Janet
mafelelo
Butste,
ya
Aninka
bontšhitšego ka yana ke ya gore
Tembeka, Dicela, please all keep
appeal
an
ela
eye on
e
the
ya
chat
go
as well
Supreme Court
to pick up if there
ge re
are
ka e
any
wina
questions that I might
then
miss.
ntwa
In the
ya go lwela
interim, we're
mafase
going
tla
to
be e
go
la
to
pele.
the
Thank you.
in-person venues. I'm going to start in Johannesburg. I'm going to take 2 questions per venue, if we can manage that. So I'll start in Johannesburg, then come to Durban, and then come to East London. Colleagues, I'm asking us to keep it as short as we can. The idea really is to facilitate some input, just so that we're not robbed of the opportunity to engage with these rich presentations.
Thank you, Babu
Johannesburg, over to
Sheputishone.
you for your first question.
Thank you. Ke kgopela ba e leng gore ke la mathomo ba tla ko pele ke la mathomo ke tima ba babedi ba mathomo okay Ntate Mabuza.
Thank you. Okay. Ngiyabonga kakhulu. But umbuto wami la question lenginayo ukuthi i-government yethu yase South Africa ipromise ukuthi itoba na 3 spheres of government, national, provincial and local. But the interference traditional leadership in local government lese siyibita manje ukuthi i-cocta it disturbed the whole process government lebe kufanele siyendeke especially in the local areas like kuma rural areas. Angikhumbuli kahle ukuthi lokhu lokukhulunyiwe kwagazethwa imithetho legazethiwe yonke ifanele ya ukuthi manje nyalo senda njani ke la ithini government ngaloku lekukhulume ngayitolo sina siyafuna ukuthi ibiyele implement lo mthetho ukuphi nyalo government uma ngabe kuviolatheka lo mthetho akhona yena usekhona yini government wase South Africa. Number 2 yeah. Oh, okay angende short question yami ukuthi usekhona yini government ngile question bengiyibuza ukhona yini makuviolatheka the whole laws lephasile eparliament yagazethu usekhona yini government na ngiyabonga.
Ke Mokhuwe Masekwa wa ko ga Motlatla mo Northwest. Ko Northwest Potso ya ka e mo goreng ka gore re itemogetse, we realized gore magosi ba na le seabe se segolo sa go tshameka ka lefatshe la merafi. Yaanong why re sa tle ka leano motlhomong le le tshwanang le re le adoptileng ko ga motlatla, ebile ke kopa gore le conference e re thuse gore a re followa tsela e right ya gore rona re batla go withdrawa status sa rona sa bogosi, which is to approach the premier re mo kopa gore we want to withdraw as traditional community. Are we correct? And re ipitse re eng ke structure se tshwantseng se betere go ka etella pele morafi. Re kopa le re thuseng go ka ya pele. Purpose ile go ka rarabolla mathata a rona. Thank you.
Translation.
Okay. Thank you very much, Joburg. Colleagues, could I ask Daniel Mwalasi to please stop sharing your screen, Daniel? Thanks so much. I'm going to move then to Durban. Durban, please, can we have your 2 questions?
One question quickly, then.
Okay, thanks, Sharami Shirinda. My question is,
Joburg, we can't hear you.
okay, just introduce yourself and then. We have in Pilra, which many are saying is interim. Yes, it's interim, and people's rights are being violated while we have this law. What is it going to happen to make the permanent law do different from the interim one? Thank you.
All right. Translation. Remabuza, una botaka ka Swati potosaka. There are 3 spheres of government. More 3 spheres of government. There's a problem here or Kokta. English, yeah, English, yeah. In the 3 spheres of government, there's interference by Kokta. That's what he's saying. Then he's also saying that what is the government? Is the government still available? Because it seems like government is actually distracted from the people or disconnected from the people. Those are his questions. Then Mr. Muku was talking about the issues of the chiefs, that they are always given the right actually to control land. And then why do we give them that particular right? He said actually where he's coming from at Hamakata village, they want to withdraw from being led by the chief. So he also said actually this particular plenary must give direction as to which structure should be established. Mr. Shirami was talking in English, by the way. So should I, oh yeah.
Go ahead, Durban.
KZN is ready. Yeah, Durban is ready.
Sanibonani. Cha owami umbuzo uthi uphakathi nezinto eziwu2 unothi kuncuka itholi siyabonga uma inesethembiso thina sasifake icala le umhlaba wamalizi ngoba amalizi vele ayesiphatha kabi njengoba singenabani singasebenzi singenzi lutho uma ngathi emzini wami sekungena ilizi sekufanele ngikhokhe unalenke uthi uzodliwa lo yamuzi engithi nami ngikhosele kunezingane ezabantu abami nami uqobo ilungelo lami likhomba ukuthi kalikho siyabonga mayisethembisa ukuthi uma kwenziwe appeal kungaphinde futhi kwenzeke kanti sawina mayethi nalabo bethi baqhubha bekulungelo ngathi ngaphinde kube njalo ngiyabonga.
Hi, Tembega. Tembega, I want to know if you said EPIRA will help us as in our communities. Tell us how or in which way.
Thank you very much, Durban. Over to East London.
Mandibulele mhlali ngaphambili elithuba undipha lona. Mna ndisuka eGwatyu eSpang. Gqiba uthetha xa zithetha ngento zenkosi ziyasichukumisa nathi. Kuba pha kuthi eGwatyu kukhona abantu azibiza ukuthi ngamatshatshu bakwaGungubele abakhokelwa ngumondli. And abasebenza nale rural development kodwa yona ngokwayo yeza kuthi eGwatyu ichaza into yokuba uGungubele bafake amabango amatshatshu amabango abo achithwa bafaka amabango ayi-2 achithwa. So ke ngokwalona lithi ubukhosi eGwatyu abukho kodwa baphinde basebenze nabo. Umzekelo omondli Gungubele bahlala eGwatyu kusuka nomtshatshu waphina uzofuna uxhamla kulo mhlaba waseGwatyu. Thina abantu singabantu baseGwatyu asaziwa noba singabantu noba sekusiza into enjani bayithatha bayise kulamatshatshu bathi kwawona abanabukhosi. So isixa ke thina singabantu baseGwatyu ngoba kaloku la mhlaba nathi urhulumente walani yena ukusinika lo mhlaba. Siyasokola eGwatyu abantwana bethu bagcwele eSouth Africa yonke nodadewethu nabantakwethu. Abantwana bethu batshaya drugs kwezi ndawo kooMakapa phi kuba kaloku akusetyenzwe eGwatyu babe kusetyenzwa ngeyonke le ngxaki esiyenzelwa nalo rhulumente naye ukhona phakathi kwale nto uba akanamanyathelo yena awathathayo kule nto yenzekayo. Umzekelo apha kuApril bekuthunyelwe iParlamente la mihlaba ekhokelwa nguMandela. Kula kuthi eGwatyu usuku layo lokuqala ilichithe eQamata noMathanzima noGungubele atshatshu kuyodalwa ngomhlaba waseGwatyu. Abantu baseGwatyu abekho babuya bezapha eGwatyu koGungubele. Ngela xesha kuxoxwa ngomhlaba waseGwatyu akukho mntu waseGwatyu ukhona kweza ngxoxo ngalamatshatshu abantu bawo. Bathe suka pha baqala beza ebantwini kwakugcwele ngabantu abangengobaseGwatyu bechaza ingxaki zabo. Sesamangala ke thina bekuthiwa kuzwa kwinto yaseGwatyu nje. Thina eGwatyu sicinizeleke kakhulu, sicinizeleke gqithi. Zininzi into ezenzekileyo eGwatyu ziwe yaphindwa eyenza noGungubele baphinda benza iland audit baqala ngeland audit beza ngeland right okwesibini kuchithwa imali. Urhulumente yena uthini ngezamali zezanto ziphindwayo ngoba zathi ezazinto la land audit ze kufumaneke ireport kuyo yaphakama iCPA yabantu baseGwatyu ekhokelwa ngabantu baseGwatyu kwatsho kwafumaneka ireport. Umzekelo kula land right sorry sisuba ndiyaxolisa ndilande ngaphakathi ngase ndikhuphe yonke le ngxaki sikuyo eGwatyu. Ininzi nje into phakathi eGwatyu yenzekayo. Enkosi.
A final question from the Eastern Cape.
Molweni, igama lam ndinguNosintu kaMcimeli ndisuka pha eNgqamakhwe eXilinxa ezilalini. Andifuna uphosisa bendinemibuzo emininzi futhi besendilahlekelwe nalithemba ngoba icacile uba xa isuka kuma-18 nto yonke le nto hayi liphelile ithemba besingobani thina. Ngoba kaloku benexhala laba ma-amalgamations of two common laws and all that ukuba abazuzise ezinye ii-fatalities nezinye ii-assassinations ke ngokubona. Which strategy do we use because icacile into yokuba uba kuzawuventurishwa to that inoba ngoku izavele ikhoze more fatalities ezizawugqitha ne-COVID-19 fatalities. Kodwa ke uMr Ngcuka ithuba ndifuna uxoka undinikile ithemba xa esithi ngoku lo umthetho ukho esingazi noba kukho naloo nto. Lo umthetho ukho udraftiwe esingazi noba udraftelwe ndawoni underground udraftwa ngubani ewudraftela bani. Ithetha ukuthi loo nto ngoyisinika ithemba lobani ba xa esithi ungascratchwa ii-powers zibe zisuka kuthi hayi madoda masiqineni from here. Anambuzo uthi whethu from here usinikile umhlahlandlela masizixelele into yobani ba ngoku kodwa kubekwe ke kule game umntu ongumama phambili ngoku. Sizixelele ke futhi into yobani ba sizawusebenzisa istrategy esithi there must be nothing anymore for us, about us, without us. Let's do it.
Malibongwe. Enkosi. Malibongwe. Malibongwe. Thank you. A brief translation of those two questions from East London. The first was an input from a community member in the community of Gwagu, who was explaining the struggles that that community is facing in relation to the traditional authority and the family of the Chachu family, of whom Mondli Gungubela, who is part of the country's executive, is a member of that family, that the family has put in various claims, and ultimately that the situation of the community in Gwagu is one of incredible insecurity, struggles, and large oppression. Effectively, the request is that they would like the return of their land, which would. The second input was on the matter of the participant feeling slightly despondent, having heard the inputs that were given today around the history of these issues of land dispossession and how far back this stretches. However, she draws hope from the input given by Advocate Mqaitubi and finds that he offers a way forward in the suggestion that the Communal Land Tenure Bill should be opposed, should be scrapped, and that the way forward should be led by women. Hence the call, Igama lamakhosikazi, Malibongwe. Members of the panel, I'm going to come back to you. We are running very short on time. I see there is a range of comments coming in on the chat, for which we thank people. I have not picked up a specific question as yet on the chat, but if I have missed anything, I would ask that the panelists try and respond to it. I'm going to ask you to be incredibly short, members of the panel. A sort of a 2-minute statement, if you can, as best you can, to respond where you see a need for response or to give a closing thought. I'm going to start backwards and start with Utembega, then come to Aninka and finish with Jonathan's term.
Ndiyabulela sisiNolundi. Kanena ndisakhumbula uba ndandokubuza uba ngumamni.
Ndingumamzima uzondo nxeke uyemyem sopityi ngumengcuko.
Sopityi onqolomzila. Yem madoda, hayi ke ndiyabulela. Usibhexeshe kakuhle wethu ngale njikalanga. Just 2 points, I'll leave the rest to other members of the panel. I think the Gwajo situation will probably be dealt with in a more structured way, because that seems to be a tangible problem that requires a structured intervention. My attorney is Velmin Wickham. She's in attendance. I think she's making careful notes to remember to deal with the Gwajo situation. But we thank the lady from Gwajo who made an impassioned plea for legal intervention in the face of aggressive expansion by a member of cabinet. And then IPILRA, my only point about IPILRA is that there are options. This idea that it's Clara or bust, that's what we must reject. There are options. There's in fact even a better option currently in existence, which is, enact IPILRA, because its premise is different. It's not the colonial premise of the Communal Land Rights Bill. And then the last point is around the government in general. I do think that there is a problem with the way in which the government approaches land issues. I think that it listens to people with power. I think that it ignores people that it perceives as not having power. I think that it marginalizes people that are already marginalized. And I think that it prioritizes the interests of people with money. And I think that tendency to listen to people with power and people with money does account for why we have laws that don't speak to the Constitution and sometimes contradict the Constitution. But the key is to always take the power back to the people themselves. We don't have the solutions, the people have the solutions. Our function is to dismantle the structures that marginalize the people so that their voices cannot be prohibited by law. The argument I was making is that the Communal Land Rights Bill is another legal strategy that will entrench the marginalization and prevent people's voices from being heard. And that's why it's got to be confronted frontally. And then there are alternatives to it. And ndiyabulela ke ngolomsilo.
Enkosi, Aninka, masive kuwe.
I don't have much to add, Nalindi. I mean, basically, you know, I hear the complaints of Solomon and Shirami and, you know, the way in which government basically, you know, is just ignoring the constitutional structure of 3 spheres of government and, you know, the situation in Gwachu where, you know, a chief was never part of the history and now is playing a prominent role. And it does seem to me that, you know, Tembeka's right, that government is not talking to the people whose land rights are at stake and is instead prioritizing the interests of traditional leaders and farm owners and other kinds of elites. I mean, the Ingonyama Trust judgment was the 3rd structural interdict that has been granted against the Department of Rural Development and Land Affairs and Agriculture, whatever it's called these days. So you've had courts go much further than just saying what government has done is wrong. They are actually forcing government to follow a particular path in putting that right. So these legal struggles, you know, are important because they keep on restricting government's power to enact these legislations. But, you know, I keep on remembering something that former Minister Nkwinti said, which is he said, you will win in the courts and we will win on the ground. And that is the tragedy, that while these matters get fought in court, government is supporting traditional leaders to do the kinds of things that happened in KwaZulu-Natal. You know, the minister supported the Ingonyama in the legislation against the in this legislation against leases. So we are up against enormous problems. And I do think that in a way, what we have to do is build on the gains we have made. And one of the gains is to get IPILRA recognized. It was completely ignored by government for years. And I completely agree with Tembeka that by focusing in on existing rights held by families, by groups, it's not trying to individualize anything, as one of the comments in the chat says. It's trying to drill down into customary law and the rights that people have as members of different groups, members of the family, members of the community. And that in a way we need to build up from that base. And in a way that is what people are already doing. And these struggles that people are waging on the ground are crucial, because if you were not waging these struggles, government would be able to say that the version of customary law that they support has become the living law. But because people reject that version of autocratic chiefly power, there is always proof that what government is trying to do is unconstitutional. I'll leave it there, Nolindi.
Thank you very much. Thanks, Anika. Ste, Janet, a closing thought?
I'm happy to come in here, Nalindi. Yes, I know. I'm sorry that I think the one delegate said it was depressing to, you know, sort of to hear some of the background. And in fact, when Ste and I wrote the background, we also found it difficult in a sense of recording, you know, of where nothing has really worked. But what I feel what today has sort of started for all of us is to recognize a problem. And what Tembeka was saying, we have to look at the now. We have to look at, where we're standing right now, and use what we've got, perhaps building a pillar up. And I think, but it's important to frame the problem, which we all know is there, and then perhaps use it, to look at, we got to somehow find solutions to this. And so I'll leave it at there. But I think that's just having a look at the very real effects of how various actions or blanket laws, where it actually drilled down and affects people's lives over the years, is a very sad and depressing thing. And I think that's where we have to move away from, and and not allow that to become any more sort of entrenched than it is. I think I'm not sure if you want to add to that, Stan.
I think I'm covered, Janet, and Aninka really hit the nail in the coffin. For me, the struggle continues, and it's just begun.
Yeah.
Thank you.
Thank you.
Thank you so much. Thank you very much to all of the panelists. This was a really vital conversation, and I think continues the theme of today around trying to describe and understand the problem. Bahlali eyami indima ndigqibile ngoku nizokhe niphumle over ilizwi lam noko yini imini le yonke. I am going to hand over to my colleague Professor Ruth Hall from PLAS at UWC. Professor Hall will take us through a brief summary of today, and then we will close and we will reconvene ourselves tomorrow.
Thank you very much, Nolundi. And coming at the end of such an intense day, I don't think I need to repeat what has been said. Instead, actually, what's going to happen now is a 30 to 40-minute workshop in each of the physical venues, in which people will reflect on today and clarify areas of agreement and which of the points raised resonate with their own experiences, where there are disagreements and areas where people would like to probe for more clarity, and perhaps some answers can be prepared in response to those questions overnight. Thirdly, the third question will be, what are specific new ideas and insights that have emerged that help to clarify our thinking that have emerged today? And fourthly, arising from that, are there specific action points or a call to action that emerge from our discussion? These four areas will form the focus of the discussion in the next 30 to 40 minutes. And I'm going to post these questions onto the chat. We're very aware that in trying to make sure that this is inclusive, and there are workshops happening in 3 venues, there are many people online. So for everybody who is joining online, I encourage you to consider the 4 questions that are now posted on the chat, and to make your own notes and reflections. And you'd be very welcome to send those in the form of an input into tomorrow morning's chat to become part of the record of this event. And in addition, we have, as the amazing rapporteur team, we have a summary of 4 pages. We have more than 40 pages of notes from today, but we have a summary of 4 pages which we will edit and circulate by email to everybody overnight, so that when we meet tomorrow morning, there will be a record of today's session. So with that, I think back to you, Nolundi. The questions are in the chat for those who are online, and the facilitators in all of the workshops will be guiding the discussion, and rapporteurs in each of those 3 venues will be taking notes on the views and responses from the participants there. Thank you very much.
Thank you so much, Ruth. Andizobamde kungekho nanto endizoyithetha kangako ngaphandle nje kobulela. Again, a vote of thanks to everybody for joining us today. Please join us again tomorrow and take some time to ponder the questions of reflection that have been posted. Ngaloo ndlela ke siyayivala eyanamhlanje. Siyabulela kakhulu. Thank you. Thanks, Melody. You can close us.
Madam Facilitator, I think my point was missed during the interpretation. And I want us to adopt this idea as a way forward and in assisting our communities. Each and every day, or each and every conference, we talk about the challenges and the problems that are aggravated by our chiefs in our various land. Now, can I suggest that or we follow suit the strategy that we are trying to adopt in Gamotlatla as a community, that we move out of this chieftaincy system, we withdraw our traditional community, our membership as a traditional community, and maybe formulate a structure that will assist the community, that will be mindful that the land belongs to the community as a way forward to can try to resolve and to marginalize the government and the so-called traditional leaders, because some of them are not traditional leaders. That's my point that I wanted to bring it home. Thank you.
Can I get? I think we have two positions that we can follow. One, can we follow the judgment by Judge Kamoseneke on Nyalala versus the CPA? The community, the land belongs to the community. The chief has never bought the land. The community should take their way forward. That is part of the judgment. Secondly, we have the law journal, which is titled The Evolution of CPAs. It indicates that the community does not need a chief. It's a chief that needs the community, meaning that if the community joins itself up, they can say, we don't want this person or status.
Is there a second mic down there? So,
yeah, tshitshinyo e ba itshikhinya ke a e utlwa, but ke tshitshinyo e ba itshikhinyang ke a e utlwa, but ke nagana gore di-problems tša rena a di tshwane. Bona if ba decide gore ba ka tswa, ne ba gopotse o tlo sebetsa ka tsela e feng, kore ba tlamehile ba tlishe structure se bona ba batlang go operate ka sona, ba se submit go bonagale gore ba na le problem mo kae, because di-problem tša rena a di tshwane. Ba bangwe ke di-CPA tša mengwaga-ngwaga, nna ga gešo a rena CPA ke di-CPA tša mengwaga-ngwaga, so is a clash between the CPA and the royal and all these things, so di-problems tša rena a di tshwane.
all right, the last point on this matter, what Mr. Mosegwa is raising is contained in the Traditional Leadership and Governance Framework Act, but it is not a one side. You are not speaking on the point. All right, I'm still taking. All right, the second question, but I just wanted to say it is contained in the Traditional Leadership and Governance Framework Act. It is allowed. And if we don't have any legislation that gives us an alternative, we can dream. Ne? We can dream. We don't have to say either or. CPAs are also having their own challenges. Traditional leadership, we have stolen our identity. I'm being heard, when I'm motlong. So there's problems, and it's not a one-size-fits-all, I agree.
Yeah, thanks. And I think my take from Temberger, he raised the aspect that the CPAs have got challenges. But I think he also emphasized that there can be a way of entrenching or strengthening our customary law. Then that brings me to the point of saying, maybe part of the focus point would be how do we, going forward from here, how do we mobilize to reclaim our democratic rights and probably campaign to correct that which is wrong with the current, system of CPAs. Because whether we like it or not, some of them are behaving exactly like the traditional leaders. Some of them are corrupt. They are there more than 7 years, 10 years. But how do we come up with a campaign to say, we are going to reclaim that which actually belongs to us, and then democratize it? Because it doesn't mean that ourselves, when we are part of the CPAs, we cannot behave like the current ones.
Thank you. And just to remind ourselves every time, when we talk about customary law or something customary, we're not talking about chiefs. We're not talking about an institution autocratic. It is the nested layers, because customary practice starts from the family, the household, and then it's been escalated. We know that we have practices of dispute resolutions that starts at home. If I've got a grievance at home, I will tell Borakadi or Malume. They sit and see how they can resolve it. And when they think it is too bigger for them, then they can escalate it to a certain level. So we must always remind ourselves, when we talk customary, we're not talking traditional leadership or institution. So I'm going to give the second speaker.
Dumelang. Na concern ya ka ntlha fela ba gaetsho ai wa itse ke pressure ke nako every day man a ke khone o botsa dipotso ka mokgwa ke batla o di botsa ke motho o ke buelang ka bonya but nako e leng gore re ifilo ena man wa itse pitlagane so much e ka ra re mo Johannesburg ko tla 2 seconds and is claro ga gona re o ka tlhalosa sepe nna ke Edwin Mogatusi ne ke tla go community ya Obakeng ke emetse ba community Obakeng community go fitla ya no se ke tshwana le gore ya no ga ke itse gore maemo a rona ko Obakeng mo melao yotlhe e fitileng yena ke kopa gore the academics researchers le activists kopa le nthuseng fo le position le reposition go Obakeng gore what is really the problem amongst baruti ba botlhe ba bantse ba bua fana gore bothata ba kwa Obakeng bo ka le bagana le which area ya ka ga lentse le tlhalosa fana le di attorneys, because ke touchelwa ke this possession disguised as a regulation. Kwa lefatsheng le re lwelelang go tsailwe di-comrades tse re itseng sentle gore di tlile ka mang, re sa bolo applyela lefatshe ga re seno re le applyela commissioner a re kopa gore bogolo re le claim ga seno re le claim ke ga di-claim di re tswalela ga di re claim di seno di re tswalela yaanong di-comrades di tla ka magosi ba tsamaya bonano ba re tlola ba ile o dirisa lefatshe in a way ya ka o kare ba etsa ecotourism model ko. So why is man re tlhakane tlhogo tota ga re itse gore sentlentle, but so se tshwenyang ke gore we still sit with them on the table, these departments leaders. Go tlhokegang ke kopa go le position go tlhokegang fo teng fo gore this problem ya rona e ka fela, because gona lefatshe le le rentse go lona 35 years. How se no ba re koba ka this positioning this one e ba re ba mo gardening, ha re tsena go gardening re applyela yona puso gore le re beile mo gardening. So ba re botsa gore ne le ka batla go isiwa ko kae go lo fudisa le go lema ko teng. Batho ba ko bakeng ne ba 120% farmers. Ba tlhaga mo dipolaseng tsa farming only. Ha ke batla gore a ke ra go no tswa sekolong. Mare they are highly trained mo farming. A go no ba berekang ko bakeng mare ba tja ba khora. Lefatshe ke le puso ya gana re le dirisa. It's just nearby. Ya no kopa le re position ba le itseng o ka nkarabang gore tota re kgoreletswa ke mang ba ke puso ke goreng ya leboga.
Ke a leboga, Papa. Os baby, the reflections of today, how did you feel? What went well, what went right? Not not logistics, but how can we improve? But the process. And then I ke go thibela re bue so no ba tlosiwa.
Ma-Africa dumelang gape. Now, the reflections here today, number one, I'm deeply disappointed gore re filwe bikinyana ya nako go araba go botsa di questions. Number two, ke fila gore le matsatsi a ra filweng for land conference are very little because we're talking land bagaetso. E dirilweng complicated ka bomo mo South Africa. Ke bona some academics ba rounda dilo tse dingwe. They don't want to be straight and to the point. Go saying I ask a question that was never asked, that was never answered by professor. I don't know, some professor on a thing. I asked him a question, he never answered me. And I'm not happy about that at all. Number two, we know we have been having these problems of traditional leaders for over 28 years now. So why do we still have a problem removing these people from our communities? Because it's a handful of people oppressing 18 million people in the country. Really? I mean, really? Now I'm still going with Mukuwe's idea that we should remove these people from our communities because we don't need them. And we know how to live our customs and traditions on our own. That's how we were raised. We don't need someone to supervise us to live our traditions and customs in any way. That's my view. And the last thing is, they know that the problem, where the problem started. Why don't they scrap the chapter 12 of the Constitution from the Constitution? Because we don't need it. Because that chapter 12 is actually promoting this corruption of traditional leaders taking what belongs to the people to them for themselves. I mean, really, it is of no use. We don't really need that, because how can you give someone to be a custodian of your land? Meanwhile, you know that you're going to use that person to steal your land. Thank you.
Thank you. So if there is no, you want to speak, I can note you. Also, Meli and Philly. So I'm giving this last three speakers, and then we close. Okay, and then Hank. Okay, sure.
All right, what I've deduced in today's deliberations? One, the Communal Land Rights Act bill. We need to ensure that it is scrapped. Then there must be consultation from bottom to top, meaning there must be public participation process. You must demand it. That is one. Two, the issue of IPILRA, we need to also push government that it mustn't actually be kept as an interim legislation. It must be made permanent. Lastly, there's a problem of a system that we have inherited from colonialism, apartheid, even the current new government has also actually trembling in the very same system. So we need to actually, as communities, civil society organizations, demand to dismantle the system that was inherited from the ZAR, colonialism, apartheid, and the new government. Thank you very much.
The
Yeah, I think for me, what stood out today in the breakaway room when we were there, the speaker who spoke about the trust, he was actually very spot on. And I think the onus is on us to really go back home to raise a lot of awareness and show how that system is actually disempowering our people. Because our people, sometimes they just like the word trust. No, rena, re ka se kgethe CPA rena re nyaka go ba trust. Ba sa tsebe gore trust ino ra gore wena o te tshepe o tšea taolo ya gago le bokamoso wa bofa motho o mongwe wa reng o tseba tše ke di hlokago. And mafelelong a sa dire tšela o di hlokago gore o tlo o montšhe mola e namela thabo ka gore yo nyaka tšhelete e ntši. So that was one thing that stood for me. And the second one ke ela gore e pilra today e kgonne gore bontšha gore as we are today, there are still rights that we are enjoying under it. So se se re šaletšeng ko gore a re tšweleng pele re popularizing. Because go na le mo ba botša question gore na a na ge gona jwale di-rights tša ka ba di-infringe ko morago ke ge re kgokasa re no šomiša iphelera tša ma o swariše kgoši gore no o dirang o interfere le tokelo tša gago. Thank you.
Ba ge šun le kae nna ke leboga ge re bile gona mo kopanong ye sa mathomo se ke se lemogileng or se sa bina le ka mo tlhogong yaka ke taba ya gore ga re tsebe sekgowa se se thata re bolela ka rena re setšhaba morafe a ke jwalo bona ba tla gape le bo community rena re tsebe community ba buya gape ba tle ba re tribe so dilo tšego ke gore re be le homework. There was a word he used, academic, bombastic, or the jargon, ambiguous definition of community. So we need that thorough understanding, maybe a mini workshop, we gather in few minutes, then we interrogate. And also, learning about those laws, especially when we come to Bailey Street, customary law or customary practices. We start from the family level and upwards. So it's not about Khosi. Khosi is also a member of the community. Like in the CPA, chieftainship versus CPA. Khosi is one of the members. And if she or he needs Bukhosi, where she stays, I will say she because mine is a woman. Where she stays, when she jumps that tar road, she's no more a Khosi. So we should also be aware of all the tricks our government is playing around with the laws that every day they talk about, they tabulate, and also the Communal Land Tenure Bill. Look at the timeline. We come from afar. But today they still take us back. But we should fight. Let's fight now. ARD and everybody to scrap all this nonsense and to fight the Bantustan mentality. Let's fight it. Take our disabled people with wheelchairs, put them in the front so that we kill their hearts. And they show some remorse and they will listen to us. This time is to fight because the land now is being taken right round back to the master. So the other issues is about Batumba Mudim, Milau Eteng Erisireletsang. That word protect and promote. How do we protect our communities and our rights? Thank you.
Mandla. Menier HS.
Thank you. Comrades, I can't be as fiery because I don't know why, but I should be more fiery. But I want to say something about what I learned today and what is different today to yesterday and before. Now, in our Lamosa, for those who were yesterday, in the Lamosa bundle, there is the summit that government had about land tenure and administration in May. And the whole program and the motivation from government is in there. And what was that about? That was about collaboration between traditional leadership and the three spheres of government. It's on page 11 of page 15 of that program. That was the theme. And the answer for land tenure issues and administration issues was, from government's perspective and at summit's perspective, traditional leaders. As it was a century ago and 2 centuries ago under colonialism. Traditional leaders will be the proxy government over our land. That was what this summit said in May. Now, today and tomorrow and Friday is the opposite. Traditional leaders and Togosi is not the answer, but perhaps part of the problem, and not for collaboration as part of government, but for real tenure, rights, confirmation, and affirmation. So it's a completely different emphasis. And it's for us to make sense of that. Then the other thing that I learned that worries me a lot is on the last page of today's program. And this shows the contradictions that we have. The sponsor, supported by, last page, the third sponsor is Department of Science and Innovation. Now, Minister Blaise Nzimande helped to sponsor today. But Minister Blaise Nzimande, in February this year, announced his Hydrogen Society roadmap. We are no longer a gold mining society. We are no longer a platinum mining society or a mining society. We are now a green hydrogen society, who are going to make green hydrogen and green ammoniac for the world. Now, green hydrogen is splitting up water into its parts, hydrogen and oxygen, and you use the wind and the sun to do the splitting, and then you make green ammoniac, which is a very more dangerous gas than we used here today, and put out the fire. It comes in round things, round humps, like a camel, a hump for a camel, and you put it at the back of the ship, and then the ship can transport stuff between China and Rotterdam, and they stop at South Africa. In South Africa, the Green Hydrogen Society of South Africa is going to provide hydrogen for the ships to Rotterdam. And Blaise Nzimande said that 60,000 hectares of Richtersveld land, which we also heard about today, and 240,000 hectares, a total of 300,000 hectares of the forgotten parts of the Sun community that also spoke today, Mr. Low and the Richtersvelders and the Bushmanland people and the Namaqualand people must give up 300,000 hectares of land for sun and wind to make green hydrogen. They give with the one hand, they take with the other hand. It's not the ministers of transport who comes and talks to the Namaqualand people about the railway line they want to put up, or the new deep sea harbor. He stays away. His name is Razmataz. What's his surname again? Then there's another minister who calls a SIP. Her name is Pat Delol. Then there's another minister. Okay, Blaise Nzimande doesn't come near the hot places. And then they don't come. They send provincial government as messenger. does provincial government have the right to make these developments? No, they don't have it at the moment. They can't take 300,000 hectares from us. But, comrades, the TKLA gives the Premier the right under Section 32. Here sits Mrs. Section 32. Ms. Section 32 is Chepu. What is Section 32 of the TKLA saying? It says the Premier can make deals with chiefs about our land, about railway lines. So that brings us back to what the summit did and what we are at. How do we deal with the attacks on our land and our property rights? And that is what is our job for the next 2 days. Thank you.
Thank you very much, guys. So those who are not confident or maybe they are generous with us and our tiredness, continue to post on the land conference group to say to you, what do you need? What do you think we can do better? So there's tea time, but I want us to break for tea and then that will be the end of the day. Ne? So I just want you guys to look at the conference for tomorrow and look at, decide already you want to go to panel A, panel B, put on the land conference where you want to go, group, so that it's easy for us to split and to plan, all right? What I want to pledge with you is that our community voices, the panel that I'm chairing, I'm not saying you shouldn't go to panel B. Please support it. Please come and support our panelists who will be speaking on that panel. Thank you very much. But
to